Good day to you, and welcome to another Paddocks Club video tutorial. One of the issues that comes up again and again on Paddocks Club and in our consulting practice is to what extent the personal circumstances of an owner affect his or her right to make changes to the common property of a scheme. An example of this was a recent query by Connie MacArthur. She said that an owner had advised the trustees that he was going to install a CCTV camera on common property to protect his section. The owner, it appears, owns a restaurant, not in the scheme but elsewhere. But because of this, he handles large amounts of cash late at night, and he says that he's being followed to the complex, and therefore he insists that he be allowed to install the CCTV on the common property. The trustees apparently responded by insisting that the owner appoint the services of a security company to handle the cash, and specifically by means of a drop box, perhaps at the restaurant, as they said he was posing a security risk to the other owners in the complex. The owner then refused to correspond any further with the trustees on the matter, and Connie asked us the question. Well, let's start at the beginning. The common property is owned by all owners of sections, and under Prescribed Conduct Rule 4, an owner is not allowed to make any changes to the common property without first obtaining the written consent of the trustees. It makes sense. While the owners have an undivided share in the common property, the trustees manage it. The body corporate manages it, and the trustees on its behalf are the ones who take the day-to-day decisions as to how the common property will be managed. Now, that PCR 4 does provide an exception for those security and insect or animal prevention devices such as burglar bars, gates and insect screens that have been approved by the trustees, but that's not applicable in this particular case. So no owner is entitled to attach anything to the common property without the trustees' written consent, except of course for the security and insect or animal prevention devices. This owner is in essence saying, I have special circumstances, so I should be allowed to do this. I run a restaurant, I need to come home late at night with lots of cash, and therefore I need these extra security measures. This thing is to install one or more cameras, wiring, power supplies, etc. on the common property, so that from some remote location, he or his agents or his security company can monitor the common property and thus increase his level of security and safety. Now, the trustees cannot simply say no. They must consider the situation and decide what is in the best interests of the body corporate. This is important. Their job is not to decide what is in the best interests of this particular owner, nor to decide whether what he thinks is right or wrong. Their job is to look at what's best for the body corporate. The immediate reaction is, of course, is it likely that installing such a device will cure your problem? But then you get into a debate as to how useful this device will be for that owner. And in the end, there's no certain answer to that. He feels threatened, so he's going to do whatever he thinks is necessary to protect him. The trustees will have a different value judgment on the situation, and they'll probably come to a different conclusion. So in the event, that's the wrong question to ask. Another reaction is, well, is it sensible to carry so much money on your person on the scheme? In Connie's case, the trustees took this route by insisting that the owner appoint the services of a security company to handle the cash. And they warned him that he was threatening the security of other owners. The owner's reaction to this, which he probably saw as an interference in his private arrangements, was to cut off all communication. Again, probably the wrong approach, probably the wrong question. I suggest that the right question is, how will this proposal affect the body corporate and other owners? Bearing in mind there's already an exception for security, so the owner has the right to install burglar bars, gates and other things under PCR 4 too. So we're not talking about securing the section, but the open common property. Firstly, if the owners feel threatened, they can install their own section security. But they need to get body corporate buy-in, owner buy-in to make whatever changes or additions to the common property they think are necessary, but that will only advantage them. Overall, it's up to the owners in general meeting to install, pay for and maintain a sensible level of security, but this is for the benefit of all owners. Secondly, I would suggest that if the trustees agree to this, they're going to have a hard time refusing the same thing to any other owner. So this could mean you have a plethora of CCTV cameras or other devices installed on the common property for the private benefit of individual owners. This could negatively affect the aesthetic appearance of the scheme generally. So these are the sort of considerations which I think it would be fair and reasonable for the trustees to take into account before making a decision. Thank you for joining me. If you have any questions, let's deal with them in the discussion forum.